I hope the slides are visible. Okay, so today's class is on patents. In the last class, you might have understood what are the different types of IPR. So today we will talk about patents. I think from today onwards till your first internal assessment, we will have all the patent classes because patent is the most important intellectual property uh, relevant for academia or for your background. So we have put a lot of stress on patent classes. So from after your internal assessment one, we will have all other IPR classes. Okay, so let's start. What is a patent? A patent is an exclusive right granted for an invention. You have to remember these words that I have written in red font. Okay, so patent is for an invention. It can be a product or a process. If it is a product, it offers a new technical solution to a problem. If it is a process, it is a new way of doing something. To get a patent, technical information from about the invention must be disclosed to the public in a patent application. Please, this definition is given by WIPO, WIPO, that is World Intellectual Property Organization. This definition of patent is given by WIPO. Here you can see the full form of WIPO also. So basically patents are given for inventing new product or process that is useful in day-to-day life. It is not for groundbreaking discoveries. It is for invention that is useful in day-to-day life. Why patent system is required? It is a debatable point, but in general, these are the generally accepted conventions that patent systems fosters technological innovation by providing an incentive for research and development. It disseminates technical information because when you are filing for patent application, you are giving all the information about your invention in that application. So when it goes public, the public can see the detail of that invention. So it disseminates technical information and it promotes technology transfer. These are the basic benefit of having a patent system in the country. What is the right that the patentee get? When you have a patent, you are called the patentee. So what is the exact right? Patent is a legal right, okay? Whatever we are discussing in this class, all these are legal things. So you get a legal right. You have a legal right. For example, when you have a house, you have a legal right for your house. Nobody can just come and start claiming that that is their house because that is your house. You have the legal right on that. That is a tangible property. But whenever we are discussing about intellectual property is an intangible property. You cannot touch or feel them. I guess sir was discussing about this in the last classes, if you remember. So, but you still get some right when you have the patent. So you are called the patentee, you have the patent. So what are your rights? Here are the two rights. This is taken from the IP Patents Act 1970. So I have just pasted this rights. If you don't understand these big sentences, I'm just telling you in a simple manner that when the patent, your patent is a product, you can stop every third party who do not have your consent from using that product, from making that product or selling that product or offering for sale that product or importing that product into India if your patent is, if you have a patent on a product. If that patent is on a process, so you can basically do the same thing, but uh, another point also included that the act of using that process, that is also included, and the same thing like act of using, offering for sale, selling, importing that product that is obtained by that process in India. So these are the basically two rights that the patentee gets. So when you have a patent on anything, you generally you do not have the exact right of making, using, or selling that product. What exact legal right you get is that you can stop every third party from using your product or whatever is written here on this page. Those are the rights that you get, but you don't get the exact right of making, using, or selling your invention. This is important. I hope you understand it. What is the nature of patent right? So patent is an exclusive right. Uh, so you can stop every third party from using doing any other thing. How long you can enjoy your patent right? That is 20 years from date of filing or priority. This is one important thing for your examination or for anything related to patent. Since you are taking the patent class, so if anybody asks this question, you are supposed to answer it correctly. In general, people think that whenever the patent is granted, the 20 years time will be calculated from that, but that is not the case. The 20 years time will be calculated from your date of filing. Okay, where the right is available, patent is a territorial right. I think it was discussed in the last class also. When you get the patent grant in India, your right is in India only. So if you have one patent and I am using that, you can stop me from using that. Since I am in India, you have the patent grant in India. But if I am in the US, you cannot stop me. In that case, you need the patent. You need to file the patent application in the US. You need to get grant in the US. Then only you can claim your right. You can enforce your right in that country. Otherwise, anybody can use your invention in that country. You don't have the right to stop that person because patent is territorial right. A patent granted in India is valid in India only. Then this is a regular question that everybody asks me. How do I get a global patent for my invention? You don't. There is nothing called global patent. In whichever country you are applying and getting the grant, you have the right in that country only. So there is nothing called global patent. You have to go to different countries. I mean, you have to file online in different countries. Then you get your rights. If you get the grant, you have the right in those countries only. So patent is a territorial right. So in this, this might not be that important slide, but this is a important slide because question will come from here and also from here, also maybe from here. And there is another important thing is that patent is called a negative right. Because why negative? Because you don't get, as I said, that you don't get the direct right making, using, or doing anything with your patent information. But you get the right to stop every third party who do not have your consent. So in this case, what happens that it's basically negative. You get something that is stop every other person, but you don't get anything that you can directly do something. Okay, so that's why it's called negative. Now, whatever I have just told you here, how can you enjoy your patent rights 20 years from date of filing? So here the same question is there. I'm giving you because this is an example for the test, for the assessment or whatever you will be having later. The same kind of question might come over there. So answer me whichever, if you have filed your patent application on 1st September 2020, your application was published on 1st April 2022 and patent was granted on September 2022, when your patent term will expire. So you have the 20 years of patent. That will be your complete patent term. So when your patent term will expire? I'm waiting for your answer. If you don't answer, then I am not going to go to the next slide. 1st September 2040. Yeah. Sunidhi, Ganga. Somebody is writing 29 September. No, that is not the correct answer. That is not the correct answer. 28 September. Oh my God, no. Please listen again. I will go to this slide again. That I will go to the slide. How long you can enjoy your patent right? That 20 years is counted from your date of filing. So when you see here, you have filed your patent application on 1st September 2040. So whoever has replied that your application will be, your patent term will be till 1st September 2040, that is the correct answer. If you are saying 29, 28, those are not the correct answer. It is not calculated from the date of grant. It is calculated from date of filing. Okay. I'm opening from the chat. People are randomly typing option number 3, option number 4. No, darling, only option number 1 is the correct answer. The date of filing, not from the date of grant. So what happens, for example, if you file one patent application and that has been granted after 3 years of your filing, so you have 17 years left for your whole term. Okay, because people might think that from the date of grant, my 20 years will start, but that is not the case. If you are not sleeping, so you can remember this will come in your exam. Then this is the first patent in India. This will not come in your exam. I'm just giving the example so that you can understand since when it started. So our first legislation in India relating to patents was Act 6 of 1856. That's a long time ago. On 3rd March 1856, there was a civil engineer named George Alfred Depening from Calcutta. He filed a petition for grant of exclusive privileges under this act for an efficient pankha pulling machine. So this is the first patent application in India. That was in 1856. The current patent act that we talk about and that we study, that came into force in 1972, but the Patents Act is 1970. Okay, whatever we are studying is from the Patents Act 1970. As we can understand, 1856 is before our independence, right? So that is the time when the British people were here, they had their own act. At that time, this was the first patent application in India. Along with patent as an IP, there is some other IP called trade secret. Okay, there is trade secret. There's so much similarity between patents and trade secret. On a same thing, you can have a patent or you can go for trade secret also. That's why I'm including this trade secret right here. Trade secrets are confidential information that may be sold or licensed. Okay. In general, to qualify as a trade secret, the information must be commercially valuable because it is secret. That means if it is public, then anybody can use it and then you lose your business. Okay. That kind of information is called trade secret. And secondly, it is known only to a limited group of person. Obviously, if it is known to everybody, then it is not secret anymore. And then it is subject to reasonable steps. That company will take reasonable steps to keep that information secret. Then those informations are called trade secret. That is one kind of IP. But please remember, there is no dedicated law in India for trade secret. Just like we have Patents Acts and Trademarks Act and something else, some IP acts like that, but we don't have any act for trade secret. You have to just keep it secret, and you have to sign non-disclosure agreement with your employees of your company like that, and it is protected through Contracts Act 1872, but there is no act for trade secret in India. In US they have an act, but we don't have an act. Please do not get confused between trade secret and trademark. Trademark is a different IP that we will discuss about later. This is trade secret. Remember the word secret. So example of trade secrets are KFC. You guys know about this KFC chicken. So the blend of the herbs and the spices that they use in that chicken, they marinate with that, that is a secret. Nobody knows about it. They keep it secret. That's why they are able to sell it. If you know about it, you will be able to make the same thing at your home. Then you don't go to KFC for eating that thing anymore. The same thing is Coca-Cola is also for Coca-Cola's the Coca-Cola drink. That recipe also nobody knows. Then Google search algorithm, nobody knows about it. what is the exact algorithm. Then MACD's Big Mac special sauce. This recipe also nobody knows about it. So these are the some famous examples of trade secret. If you can keep anything secret that nobody knows, that if your competitor knows about it, they might replicate and they might make you out of your business. So that kind of confidential information that is very important in trade and business is called trade secret. Somebody is writing roll number, this and these are present. We don't bother. We will send you the attendance link. From that only you sign it. I'm not going to check the chat box to see which roll number is present and which roll number is not. Anyway, so that is about trade secret. So what to choose? When you have an invention, whether you go for patent or you go for trade secret. So here are some points that you can think about if you have an invention and if you want to choose between whether you want to go for patents or you want to go for trade secret. So for example, for patents, there are some subject patentable also. You cannot have a patent for those inventions. But for trade secret, there is no subject matter. If you keep it secret, that's your trade secret. If that has got some value in the business, that is your trade secret. There is nothing called subject matter eligibility or something like that. For patents, you have to file the patent application. You have to write all the details in that, and then you uh, file it with the patent office, and then patent office publishes it. So it goes public, right? The publication is the important factor for patent. But for trade secret, there is no publication. If one publication is involved, then it is not secret anymore, right? So it is typically here you can see that protection can last indefinitely. So as long as you can keep your information secret, it is a trade secret. So it can last indefinitely as long as you are able to keep it secret. But for patent, it is a 20-year term from the date of filing. It will not be extendable. So again, if you are sleeping, I'm telling it over and over again, patent will not be extended after the 20 years term is over from the date of filing. But for trade secret, you can extend it forever, because as long as it is secret, you have that trade secret, you have that IP. Then maintaining trade secret is it doesn't require actually much of your money, because you can just keep it secret. But for maintaining patent, you have to pay some renewal fee to the patent office. So it is a bit higher cost. Then it is trade secrets is difficult to maintain. It's difficult to enforce also, because you have to just keep it secret. But for patent, when you have the patent, you have some legal things. Any other person cannot take it or things like that. So it is easier to maintain. But patent trade secret is difficult to maintain. If some other person comes to know about it, then you lose your IP. So these things you have to think about when you wanna go for patenting, or you are thinking whether I have to go for trade secret or not. If you think that you have something that will run forever in the world, for example, KFC recipe or the Coca-Cola recipe, you can, if that company had gone for a patent on that recipe, then actually after 20 years they lose it. They lose the market, right? Because it goes to public domain. Anybody can use it. But since they are using trade secret, it's forever. So the company is able to run forever. They didn't actually pay anything. They didn't file any patent application. They didn't pay any renewal fee for any patent. They're just keeping it secret. So they are able to run for lifelong. Okay. So trade secret, the term is lifelong as long as you are able to keep it secret. But for patent, it will be 20 years only. And but for trade secret, it is susceptible to independent discovery. For example, if you are very passionate about the KFC recipe, you try at your home with different spices and somehow you find it out the exact similar taste, then maybe you have found it. Maybe you have found it. So actually, it's susceptible to reverse engineering. Anybody can try and anybody can do it. Then you might come out of your own business. But for patent, they have some they have some specific rights. So nobody can use that, or nobody can make use whatever all the things I have just told you. So for patent, it is easier to maintain. For trade secrets, it's a bit difficult to maintain, but there is no money involved in trade secret. For patents, there is a money involved, and trade secret can last lifelong. Patents can last smaller, shorter period of time, only 20 years. Okay. So patent is for invention, not for discoveries. This line also you have to remember. Yeah, I'll give one question also from here. That patent is for discovery, true or false. So everybody, whoever is sleeping right now, they will say patent is for discovery. They will put true, they will get 0 marks. So remember, patent is for invention, not for discoveries. Patents are for invention that is useful for day-to-day life, not for groundbreaking discoveries like Earth has gravity or relativity theory or string theory or anything that has got enormous effect in the scientific world. For example, why we do that, why the patent system is not being given, why patents are not being given to groundbreaking discoveries, because if you give, for example, I am Newton and I found that apple is falling downward, so earth has got gravity, I'm Newton, okay? So I get a patent, somebody gave me a patent. So what I'm doing, I'm stopping every third party from using gravity. Is that even possible? That's not possible, right? Or think about it, I am Einstein. I invented E is equal to mc square. Then I got patent and I stopped every third person from using that equation. In that way, I'm stopping the science on earth, right? I'm stopping every person to do their own research. So this is not feasible. In that way, you stop the science from growing. So patent system is not for that. Patent is not for discoveries. Discoveries will always be open for public to use, for researchers to use, for uh, more discoveries to come on earth, and so that our this system, our human civilization can more prosper, right? Prosper more. But patent is for invention. For on the screen, if you're not sleeping, on the screen there is an example of safety pin that you can put and pin some things together. That is useful for day-to-day life, right? So in the year 1849, somebody named Hunt in the US, he got a patent for this safety pin. So you can understand the thing that is very useful for day-to-day life, those things will be eligible for patent, but not any groundbreaking discoveries, because you are not going to stop the scientific progress of mankind. Okay. So generally, patent applications are mostly filed from applied science departments, not from pure science department. Okay, this is just a regular line. This is not pure science. Also, if they find some application in day-to-day life, they can also file patent application. Because in general, that is the case, that this is mostly filed from applied science department. Applied science, applied physics means basically engineering. So mostly engineering departments or biotech departments, any technology or engineering departments are more uh, eligible to file patent application. In general, pure science, when they are discovering something or when they are finding out some formula for something, those things are not patentable. Those things are used for further more research, for the progress of mankind. What is an invention? So as I have been talking about, patent is for invention, not for discovery. So the question comes here, what is an invention? So this line is just pasted from section 21G of Indian Patents Act 1970. Okay, this is one another important question. Indian Patents Act is from which year? 1970, 18, 19, 2000, something like that. I will give 1970. Please remember this. So invention means a new product or process. That is the first condition. So your invention must be novel. Novel means a new product or process. Second condition is involving an inventive state. So it must have inventive state. Third condition is capable of industrial application. So the word inventive state, sometimes it is called as non-obvious. That means your invention is not obvious to the person skilled in the art or to a general public. Your invention is not obvious. Okay. Inventive state and non-obvious, these are synonymous, but the term obvious, non-obvious is used in US Patent Act, and we in India, we use inventive state. That line we use. Then for the third one, must be capable of industrial application. That means it has got some utility. It is useful. Okay, but according to the Patent Act, we use this terminology: first novel, then inventive step, then capable of industrial application. So these are the three things that is important for your examination. So write down this slide number. Question 3, for this patents, by now I have told you so many questions that will definitely come your assessment number 1, that is on 28th October. By that time you might forget, but you can write it down somewhere, that these are the three important steps for an invention to be patentable: novelty, inventive step, industrial applicability. Okay, these also will come in your exam. These are the definition of novelty, inventive step, and industrial applicability according to our Patent Act. For example, novelty is that it has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of the patent application. That means that it is not in the public domain. Novelty means new. Okay, that thing is new. That is very obvious that when you are filing a patent application that has already been there in the world, then there is no point to file the patent, right? By the way, when I use the term file patent application, that basically means submit your patent application to patent office. In legal terminologies, that word is called as filing. Okay, submit, submitting, sending, whatever it is, that thing is called as filing patent application. So novelty means anticipated. You can see the word anticipated here. That means nobody has known about it. Anticipation, you know the basic English word anticipation, right? So nobody has known about it through any publication, any open publication that you can search online and you can find it. You can find it, or any other publication that is available in a leaflet or pamphlet or books or things like that. So it is not in the public domain. The word we use is it is not in the public domain. Then it has not also been used anywhere. Maybe it's not written, but it is being used. So those things are also not patentable. Those things are also not novel. Okay, so this is the first criteria of novelty. So you basically have to remember these three lines, but I'm just explaining it in detail so that you remember if you have to, if you want to remember. Then second step is inventive step. It involves technical advancement. So basically, when you are filing a patent application, you definitely have something that is advancement of whatever is already there, right? Some modification, some benefit you have added to that, then only you are filing it. So it involves technical advancement as compared to existing knowledge or economic significance. For example, if some product was already there, somebody was already making it with a lot of amount of time and a lot of amount of energy, for example, a lot of temperature is needed to make that product, but now you are able to make it in room temperature, then actually you are reducing the cost of making that product. So that will still be patentable because economic significance is associated with that. Or if that earlier that was taking time of 1 day to make, now you are able to make it within say half an hour. So that is also reducing a lot of labor, lot of time. So that is also economic significance is associated with that. And that the whole thing, when it is not obvious to the person skilled in the art, in that case we call it has got an inventive step. Any question on this? Inventive step might sound a bit odd, might sound a bit, you know, complicated. If you have any question, you can ask me in the chat. Since I don't see any question, I assume that uh, you're you don't have any question. Okay, so the third one is capable of industrial application. That means it is useful. I have already told you here that capable of industrial application means it is useful. Here also the same thing is there. This is the flow chart for determining inventive state. Maybe you can go through it if you are interested. This is basically inventive step when you find, if you have your own application, if you have something else that was earlier, so you compare between both of these and you see whether it is obvious to the person skilled in the art or not. If it is obvious, then it is not patentable because inventive step is not there. If it is not obvious, then inventive step is there, then you can file the patent application. Then here is something called FOSITA. It is important in the Patent Act. The person having ordinary skill in the art. So the letters FOSITA, you can see it's written in red. So PHOSITA. If you add them, it becomes FOSITA. It is a hypothetical person, but when the patent examiner will examine your application, the patent examiner will think about any FOSITA who is working in that field, maybe researching in that field, or working or using that those kind of thing for a long time. So those people will be your FOSITA, the FOSITA for that patent application. This is a hypothetical person, and it's very frequently used in Patent Act. So here just, you have to, you can go through this slide. It's not that important. It's, you have to understand whether your invention is obvious to a person skilled in the art or not obvious. If it is not obvious, then it has got inventive step and then it has got patentability. So patentability of your invention, the invention passed 3 criteria of patentability. Supposing that your invention, so you have now understood the idea of patentability criteria. By the way, these three are called patentability criteria. This is not written on this slide. Sorry about that. These things are called patentability criteria. So when I'll give you the question will be, what is the patentability criteria? Then I will list all these three. Then you have to say, yeah, that is the one. Okay. It's called patentability criteria. Now let's go to this one. Okay. So now you have understood the criteria for patentability. So there are 3 criteria and you have satisfied those criteria also, and you have filed the patent application. So you are excited that you are going to get your patent soon. However, the Indian Patent Office still rejected your application. What went wrong? You invented a device for theft and burglary. That was your invention and Patent Office rejected it. So there is still something that can stop your invention from being patentable, is that Indian Patents Act has got 2 sections, section 3 and 4, that is for non-patentable subject matters in India. So here with some Venn diagram, I'm trying to make it clear that when you have your invention has got novelty plus inventive step plus industrial applicability, that thing will be called an invention, right? However, in invention, take out of the subject matters that is falling under section 3 and 4. Only those things, whatever is remaining, those things should be invention. Okay. So in the Venn diagram also you can see these things are overlapping with all these 3 criteria. So this is an invention, right? This is an invention. But if there is something that is falling under section 3 subject matters or section 4 subject matters, so you have to carve those things out. Only this part of your invention is patentable. Okay. Okay, so there are a list of non-patentable subject matters in India. If you know it, it's good for you, because when you file the patent application beforehand only, you will be able to understand that these things are not patentable in India, right? So after this section 3 and 4, I have one exercise also. So please listen to it. First of all, if it is contrary to well-established natural laws, it is not patentable. So whatever I have listed out in these slides are not patentable in India. So these are under non-patentable subject matters. So if your invention satisfies the criteria of patentability also, still it might fall in this subject matter. So that will not be patentable in India. Patent Office will reject your application. Okay, so better you remember it. First is anything that is contrary to well-established natural law, for example, perpetual machine. You are not giving any input, but you are getting an output for that. So that kind of thing is not patentable. Then if it is contrary to public order or morality, or if it causes serious harm to human, animal, plant, health, or environment. For example, a device to assist counterfeiting or currency notes, that is against public order, or a device that you are using to reduce the oxygen level in such a way that every animal and every plant, or forget about plant, every animal dies. That is your target, right? So you are basically doing some harm to plant health and environment and human and also animal. So those things are not patentable. If it is against public order, morality, or causing harm, those things are not patentable. Then mere discovery. This line I have told you earlier also, discovery of a scientific principle. For example, E is equal to mc square. Formulation of an abstract theory. For example, discovery of black hole or string theory. String theory is an abstract theory. I hope you guys know about Professor Hawkins. So string theory, these things are not patentable. These are for the basic research in the world to go on. You cannot get a patent for those things. Along with that, discovery of any living thing or non-living substance occurring in nature. For example, if you go out to the sea today and you go for a scuba diving and you find out one new plant species or new maybe I don't know, new animal species or new fern, something like that, but that thing was already there. You discovered it. That is not an invention. You discovered it. You do your science, you do your research, but you're not going to get a patent for that because that is not useful for the day-to-day life in human society, right? So for example, a new species, if it has been discovered, a new planet, if it has been discovered, for example, Pluto, after Pluto also we find some new planet. That is a discovery. That is not an invention. So you're not going to get a patent for that. Okay. You cannot stop every third person from using that planet. That doesn't even make any sense. So discoveries are not patentable. Then discovery of a new form of a known substance. For example, you know one substance, you make one isomer of that, you have L of that, you get a D of that. Okay, you guys are not from chemistry, right? But you might be able to understand it. L isotope L or D form anyway. So if you find any different pure form or metabolite or polymorph or salt or ester for that, those things are also not patentable. Then if you just mix something, for example, you mix salt and sugar and put some water and mix some drink, but if you mix in a such a way that that is so great that you think, okay, maybe you can file a patent application for that, so that is not patentable because that is a mere admixture. In that water you are getting the flavor of, you are getting the taste of sugar and salt both. That is not patentable. Okay, so mere admixture is not patentable. Then mere arrangement or rearrangement or duplication of known devices. For example, putting a torch on top of umbrella. It might be useful in day-to-day life, as I have been telling. So you might ask me that this is useful in day-to-day life. Why not patentable? Because you can carry the torch in your hand also, an umbrella like that also will work. You didn't do anything that is not obvious, or you didn't do anything that is completely giving something completely different result. So these things are not patentable. Then method of agriculture, horticulture, method of producing mushroom or whatever it is, algae cultivation, these things are not patentable. Then medical and surgical process, any kind of process, for example, cataract surgery or whatever surgery it is. For example, I got some wound here and maybe I need to do some plastic surgery. So those kind of thing, any medicinal, surgical, profile, therapeutic, those kind of processes are not patentable in India, but it is patentable in other countries like US. So if you have found, if you have invented something that is some medical process, you better don't waste your time for filing in India. You have to go to US. Then only you can get your patent grant, and that will be enforced also. However, there are some rules that you cannot directly file in other countries without filing it in India. We have the next class for you to explain all these things. For now, you just remember that medical and surgical process are not patentable. For you guys, it's lunchtime and I understand you guys are very tired, but I have the exercise coming on. So again, plants and animal in part or whole. You cannot patent the banyan plant. You cannot patent any plant or any animal or the whole thing or any seed or variety, anything. Those kind of things are not patentable. We in India have a different act. These are IP. But we in India have a different act called Plant Varieties and Farmers' Right Act 2001. You have to file under that IP Act. Okay. You don't go for patenting for these things. Then any mathematical or business method or computer program per se or algorithm. These things are not patentable. Any literary, dramatic, musical, artistic work or any other aesthetic creation like cinematographic works or television production, these things will be under copyright protection. So you can file your copyright for that, but you don't get a patent for these things. Okay. May a scheme or rule of method of playing mental act, method of playing or performing mental act, for example, playing chess, a very innovative way, very, brilliant way of playing chess that you can always win. Maybe you know that, but that method is not patentable. Any teaching method, whatever I'm doing right now, I cannot patent it. Then presentation of information. For example, railway timetable, railway that station, or the whole Indian railway, they'll have their timetable, right? That is a presentation of information, but they cannot get patent for that. They might have their own copyright. Then topography of integrated circuit. You guys are from CSA and IT, right? You guys know about IC, integrated circuit. The design of integrated circuit, that is also not patentable. There is a separate act for that. That is IC Design Act 2000. Then traditional knowledge. For example, in India, we have a lot of traditional knowledge. We know how to use turmeric, how to use neem, and then tulsi, all these things. And these are, and they have some medicinal properties also. So if you think that you might be able to use that in your invention and you claim that property as your own invention, then that is also not patentable. This is called traditional knowledge. Okay. So what happened, some 20 years ago, 20 or okay, maybe it's 20 or 30 years ago, somebody in the US filed a patent for the use of turmeric. That turmeric has got some antiseptic property, wound healing property, that they used it and they filed a patent application, and US patent office, they granted it. Because at that time they were not aware of the fact that India, there is a traditional knowledge. It is a common traditional knowledge in India. Everybody in India knows about it. They didn't know about it. So what we had to do, that we in India, along with CSIR, we made one traditional knowledge digital library. So there we have kept all our ancient data. Almost 0.3 million medicinal formulations are available in that TKDL. We call it TKDL. Okay, this is another question. What is the full form of TKDL? Okay. So a lot of different medicinal formulation, like Ayurveda, Siddha, Unani, Yoga, these things have been translated into different international languages like English, Japanese, French, German, and Spanish, and these are now available to the patent offices. So whenever they in US or any other country who are not aware about India, they file any patent application in their patent office, then those patent examiner, they can access our TKDL database and they can understand whether it is already there as traditional knowledge in India or not, and they will stop those patent application from getting grant in those countries. Okay. Then there is section 4. Up to that was section 3. Then there is section 4. Section 4 has got only one subject matter, that is anything that is relating to atomic energy. So if you have anything that is using any radioactive material, any radioactive reactant, or you have the product is radioactive itself, in those things, in those cases, the patent office will send, our patent office will send it to Department of Atomic Energy. Okay. So unless and until they are getting the NOC from DAE, Department of Atomic Energy, they will not process your patent application. So these are the non-patentable subject matters in India. Now you have your question. Here on this, on your screen, what is this? Okay, so on your screen, you have 8 inventions. You have to tell me whether they are patentable or not. You just write in the chat box, yes or no. For example, 1, 2, 3, 4, 5, 6, 7, 8, right? So 1 yes, 2 yes, something like that. Whatever you can, you have to type in chat box. If you just write no or yes, then I don't understand. You have to write 1 yes, 2 yes, something like that. Then I understand whatever you understood or whatever you are trying to write. 2 yes. Yeah, you are right. 2 yes, surgical instrument is yes. 1, first tell me about 1. 6 yes, 1 no, 2 yes. Excellent. 1 no, 2 yes. Yes. 3 no, yes. You are right. 3 no. 7 years. Ah, okay. What is 7? 1, 2, 3, 4, 5, 6, 7. 7 years. 7, I think, algorithm. Are you talking about algorithm? That is no. Why jumping to 7 all the time? So 1 is no. So everybody understood 1 is no. Okay, somebody is writing everything. 1 no, 2 yes. That I will see. Somebody wrote all the things. Where are you? Where is that? Ah, Sunidhi. Sunidhi wrote 1 no, yes. 1 no, 2 yes, 3 no, 4 no, 5 yes, 6 yes, 7 no, 8 yes. Awesome. Sunidhi, you get full marks. Yeah, so whoever is not able to understand, you can talk to Sunidhi or you can ask me also. Looks like Sunidhi is going to get full marks in this exam. Okay, somebody is saying 2, 6, 8, yes, remaining no. 2 surgical instrument, 6, what, 1, 2, 3, 4, 5, 6, 6, making a medicine, 8, yes. Korada Chaitanya, yeah, 2, 6, 8 is right. So everybody, you just refer to this answer that is given by Sunidhi. She wrote all these things, 1, 2, 3, 4, 5, 6, 7, 8. That is the correct.
Class online.
Class is going on. Another person also wrote 1 no, 2 yes, 3 no, 4 no, 5 yes, 6 yes, 7 no, 8 yes. Yeah. So you guys are going to get full marks in the exam. So any other question or do I have anything else to tell you? Let me check. No, that's all for today. So I will stop sharing the slide and I will ask, let me see what is the time. 2:20. So what you can do, you can take a 10 minutes break and come back at 2:30. We have another session for patent filing and prosecution. My colleague will take that. So you can do that also. If you want, we can start it right away. But before that, if you have any question, you want to ask me any question, you can ask that also. I will stop sharing it. Or are you still typing? Yeah, Divya, Dillo. Yeah, you guys are going to get full marks. So I will stop sharing it. And I'm here available for you guys to ask any question. What is this roll number 65 present? I don't care. What I am supposed to do? Roll number 65 present? Yes, well and good. Sunidhi, can we reapply a patent? No. Once your patent term is over after 20 years, it is in the public domain. It cannot be extended. Some of the IP, for example, trademark and geographical indication, we will discuss about it later. Those things are patentable. Sorry. Those things are extendable. You can extend their term, but for patent, you cannot extend after 20 years. And anything reapply means what? It is already in the public domain, right? What do you mean by reapply? Like it was already there, again you are applying, then it is not even satisfying the novelty criteria. Then there is no point of having a patent. Ankam Tulasi, Mahalakshmi. Last class we were unable to attend. Can you get the PPT? The PPT is not there. I can share the link also. Let me think about it. I can share the YouTube link also for last class. Do one thing. I'll share in the WhatsApp group the YouTube link for the last class, and this class also we will upload in YouTube. Whoever is not attending, you can go and attend that class also. Can we directly apply patent in US from India? Yes, you can do that, but you have to take permission from Indian Patent Office. Without informing them, you cannot do that. You will get the permission. You will get the answer within 21 days. The controller will reply. That is also one specific timeline. Within 21 days, you will get the reply from controller. But you cannot apply without telling them. That is an offense. That attendance link also I will share, and that tension that Mohsin Hassan Muhammad you are getting about roll number 65 and present and present and present. You don't have to worry about it. We will send the attendance link and you can just sign over there. We will not take attendance like that when you are writing in a chat. Okay, you have to do that in that Google form. We will send it. So any question, or we will directly jump. So it's on to you whether you want to have the class right away, or you want to take a break and come back at 2:30. You tell me, then we will do that accordingly. Yeah, I'm waiting. You have to tell me. There is no negative marks for telling whether you don't need a break. You can continue. Okay. I'm thinking that is the representative answer for all of you. So we will continue. If I apply for a patent and what if happens product, what uses my product before I get my patent? Okay, I didn't understand. Vandana is asking if I apply for a patent and what if someone uses my product before I get my patent verified? What do you mean by verified? Do you mean grant, patent grant? No. So your what is this? Yes. Okay. So use your product. Do you mean? So they will check the date of filing. Okay, your date of filing they will check before your patent is granted. If somebody is using your product, that is also not a problem, because your date of filing will be your priority date. From that date only they will check the novelty. Your priority date they will check the novelty. Priority also in the next class you will be able to understand it better. But once you have filed it, then you don't have to worry about it. But before filing you cannot do that. So your novelty also will be lost if you have published it before filing it, if you have used it before filing it. Okay, Vandana, am I answering you? Did I get your question right? Okay. So if you file, you are safe. But if somebody else was using that product and now you are filing it, then your invention does not have novelty because it was already there. Somebody else was using it. So that guy can file opposition if you are not related to this person and if that was used earlier. And if you are related to that person also and that product was being used earlier, then you file patent application, then also you don't have novelty. Okay. That word verified word is not utilized in Patent Act. We use the word granted. Okay. Okay. So what else? Is there any other question, or we can I can just stop and my colleague can start the class.
Do they need any break?
No, they don't need. They have already written. They don't need a break. You can continue. Okay, so I guess that you guys are okay with my class. If you have any question, you can ask your CR also, and they can drop a message also in the WhatsApp group. So that's all for me from me today. I'll be back in November. Okay, bye.
నేను ఇప్పుడు చూడు అట్లీస్ట్ చేస్తున్నా Hello everyone. Good afternoon. Can you guys hear me?
Yes, sir.
Yeah, so this is the peak lunch time, I understand, because but we have been given this time slot. That's the reason we have to say. So let's go to the next slide. Slide is further expand. So I just wanted to discuss about, I just wanted to recall whatever ma'am discussed, and in addition to that, I am going to discuss about key features of Indian patent law. So, just now you guys come to know that how to protect your invention. So your invention, that means if any idea, if you want to protect it, like so any kind of product or any kind of process or any product by process. So these three kinds you can be protected. For example, if you have come up with a new product, or if you have come up with a new process, so both can be protected by using the patent. So patent is nothing but, so you might have understood, right, what is patent and what are the intellectual property rights and everything. So by using by using patent, you can protect a product and as well as processes. So allowing inventors to protect the end product and method of making it. That means any product by process. See, after some process, after you follow some process, you will be getting one product. Even that product also, it can be patentable. So it is a 20 years term. The term of the patent is 20 years from date of filing. So you need to remember this is from date of filing. patent in India have maximum validity of 20 years from the date of filing, providing inventors with exclusive rights for their invention during this period. During this period, whoever files the patent, that means patent applicant, he will be getting a rights, intellectual property patent rights, that is the exclusive right and which is a negative right. So what is that during what is the term of the patent is? It is 20 years. During this time, since from the publication, he can avail, he will be having the rights uh, uh, which are negative rights. He can exclude others from making, using, selling, offer for sale, and importing. All these rights since from the date of publication, provided if the patent is granted, he can avail this kind of rights. And another one is examination and request. So I need to mention that the moment you file a patent, it will be published after 18 months automatically. After that, you need to request for the examination. So especially you need to request for the examination. Why? Because patent applications are examined only upon request, allowing inventors to defer examination until they are ready to pursue patent protection. That means it cannot be extended infinitely. It is a 48 months from the date of priority date. So I'm repeating, it is 48 months from the date of priority. Within that time, you need to send the request for examination to the patent office, because your patent will be filed in your patent office. So within 48 months from the date of priority. So I will be discussing what is date of filing and what is date of priority in detail in further slides. So, and pre-grant and post-grant opposition. Pre-grant opposition is nothing but the moment you file a patent, till it gets a grant, in between any time, anybody can oppose, any person can oppose. So that is called the pre-grant. That means just before the grant of the patent. So during that time, anybody, any person can oppose your patent. So once you file a patent, so that will be scrutinized after publication. Whenever you request for the examination, the patent examiner will check for the novelty, inventive step, and industrial application. Ma'am, just she might have discussed what is novelty, what is inventive step, what is industrial application, and all those things we will discuss in further slide. And post grant opposition is something like, after the grant of the patent, uh, since from the grant of the patent, 12 months from the grant of the patent, in between that time, you can oppose patent, anybody's patent. Any interested party only can oppose. So this is the post grant opposition. So in a summary, like during the, since from the filing of the patent and before the grant of the patent, anybody can oppose your patent. So after the grant of the patent, since 12 months from the grant of the patent, anybody also can oppose. That is called post grant opposition. So fast track appeals. Apart from this, another silent feature is the fast track appeals. For example, I said within 18 months, your patent application will be published from the date of priority. So within 18 months, the application automatically will be published. So if you want your patent application to be published expeditedly, so that is called proactive publication. You can publish it by requesting the patent office by paying the extra. So there is a separate form for that. So you can request that, and within 1 or 2 months after you request that proactive publication, that will be published within 1 or 2 months rather than waiting for the 18 months since from the date of priority date. So those timelines and everything we're going to discuss in detail in the diagram by showing, I will show some diagram. I'm just telling what are the key features of Indian patent law. So biodiversity and traditional knowledge protection also. For example, turmeric, neem, or some yoga related posture or whatever may be. These things are specific to our traditional knowledge and our biodiversity stuff. Some people in the world, maybe in some countries in the world, they are filing a patent on these kind of areas. To avoid that, Indian government has come up with biodiversity and traditional knowledge protection databases they have come up with, so that if anybody files on these kind of areas, like on our traditional knowledge, for example, neem or turmeric, there are some instances that happened in the history, especially in the USA. Somebody filed a patent on this. because that is our traditional knowledge. Traditional knowledge thinks nobody should get a monopoly, that is a patent. So that's the reason we developed a database, so that if any patent office, if anybody get a request, any patent office get a request from their country, so they can check our database and make sure that it doesn't belong to our traditional knowledge. Then they can give the patent. That's the reason we developed this biodiversity and traditional knowledge database. So this is also one of the silent. And next one is publication after 18 months. As I said earlier, patent applications are published 18 months after filing, after priority date, and streamlined timelines. So nowadays, earlier it takes a long time for granting the patent. Now the patent office have come up with, within 2 years also you can get a patent, even 1.5 year also, by using the expedited publication, and as well as request for examination also, that can be expedited by paying the extra fee. So those provisions also, and patent office also actively trying to grant the patents by examining the patentability criteria in fastest possible way. So and also compulsory licensing. This is compulsory licensing. This I will discuss about after. In further classes, I will be discussing what is the compulsory licensing. Because after the grant of the patent, it doesn't mean that actually government gives the monopoly to exclude others from making, using, selling, and importing. So there are some limitations for this monopoly. So those limitations part we will be discussing about compulsory licenses. For example, during public health emergency, for example, if anybody is having a vaccine for COVID-19, so if he is having a patent on that, and that vaccine will solve all the problems, then Government of India, without the consent of the patentee, it can grant a compulsory license to some manufacturing company where it can produce the so many vaccines for our country. So there, without the consent of the patentee, government can issue a compulsory license to some manufacturer to produce vaccines for entire country. So especially in the public health emergency. But in the case of COVID-19, during the COVID-19 emergency, so government has not issued any compulsory license. Any public, though it is considered as a public health emergency, because some patents that involves trade secrets, that those things I will be discussing in the later part. So, and next one is working of patents. This is also one silent feature of the Patent Act. Once the patent is granted, there is a mandatory that every 6 months you have to show it to the government that this patent is working, and this patent is patented invention is commercially available in the country. Like uh, some person has taken your consent, and you have given a license to them to use that. So commercially it is exploited. So that information you have to provide it to the patent office for every 6 months. This is the mandatory. Why we have to provide, and all we will discuss further in the further class. Research and development exemption. So for example, you can find a patent and you wanted to experiment that, and you wanted to come up with further improvement or further advancement in the existing technology. So in that cases, personally you can use it, or for research or experimentation without a commercial purpose, you can use that. So then that is not called as infringement. Infringement basically means like without the consent of the patentee, the person who got the patent, without the consent of that guy, if you started using, selling, or importing, then that is called the infringement. So for the purpose of research and experimentation, yes, you can use that. That is not considered as infringement. Though you don't ask any consent from the patentee, still it is not considered as a infringement. So apart from that, International Patent Cooperation Treaty. So that also I will say, because for example, you want to protect your invention in our country, and also you wanted to, you think that your patent, your invention is having potential in some other countries as well in the world. So in that cases, you might use the International Patent Cooperation or Paris Convention. With the help of that, you can file your application in other countries and you can protect as well. So those things are we gonna discuss. So I just discussed it, like what are the silent features of the Patent Act, and let's move to other slide. So if you have any doubts, you can ask me. At any time. So now I am going to discuss about patent related activities. Especially you guys are from computer science and information technology, right? So I am going to discuss with the patent what are all the opportunities. So what are the activities that you can do that normally will happen with the patent. So normally patent related activities are, first of all, patent analytics, and patent. Next one is the patent prosecution. Actually, that will happen in the patent office. And patent analytics is nothing but the searches and the corresponding search of your invention, potential invention. All those things we will be discussing right now in patent analytics. And patent prosecution is nothing but whatever it happens in the patent office. After that, patent infringement. Once patent is granted, after 12 months since from the grant of the patent, so the control of the patent office is over. And so if you want to, if your patent is infringed, so you need to enforce it. The enforcement part will be done through courts, so Indian courts. So those parts we'll be discussing in the patent infringement. And apart from that, mergers and acquisition, those things, that is the fourth. These four activities: patent analytics, patent prosecution, and patent infringement, and mergers and acquisitions or commercialization. These four are very important activities that is happening in the patents. So as a computer science student, so you guys will be having scope. You no need to become a lawyer to practice patent analytics. So any science student, see, any degree student can practice it, but any science student, why I'm specifically saying, you guys are from computer science, right? You guys can get a career in patent analytics as well once you finish your degree. So if you are thorough with these things, these are just kind of searches. So there are some free database. If you are able to search the invention in question, which whether it has to be patentable or not. So these kind of searches you are thorough, then you will get a job prospectus. So I'm insisting, just please pay attention on this, so that this is not for the exam. This is whoever want to get a job. This is the era that some 20 years back. I finished my engineering 20 years back. That time, after you finish your engineering in the campus or once you come out, you need to get a job. That is the only goal. But in this era, it's not just getting a job. You need to, nowadays, you need to have some inventorship, I mean, entrepreneurship qualities as well. And you need to know how to protect your inventions. These other skills also matter nowadays, because it's just like, if you know some C, C++, or whatever the language with that, you can get a job, but surviving in a long run, which is very difficult in the field of computer science or IT. So those days are, I am talking about in 20 years back, that was the case, but now you need to know about invention. That's the reason you guys are studying about intellectual property. So please pay attention. Here you can grab some opportunities after you finish your engineering. So patent analytics is nothing but what is the objective of the patent analytics? Involves data-driven analysis of patent information. For example, you have some invention and you don't know like whether invention is useful. Some idea, imagine you got some idea and you are experimented with those idea, and you feel that that might be nobody else in the world have come up with has come up with that kind of idea, and you feel that this is a kind of invention and I wanted to protect. So if you want to protect the invention, patent invention, So you need to know the analysis of patent information to make informed decisions in various aspects of intellectual property management. For example, if you feel that that invention is having potential, you cannot just blindly go and file a patent. So before that, you need to search it, okay, in non-patentable literature and patentable literature. That means it's something like a Google search, where you will be searching that this invention is already available in the public domain or anywhere else in the world. So you need to search in patentable databases as well, and as well as in the Google also. So further, there are some links, some free databases are there. I will give all that information in the further slide. And see, this novelty search is basically the invention you have come up with. Something might be having in your mind that I can come up with some invention. So if you feel that that invention is patentable, first of all, you need to do the novelty search. So what basically novelty search is, it determining if invention is a new and inventive by comparing it with the existing prior art. So in the world, whatever is available, that is the existing prior art. So you need to compare with the whether my idea or invention is available in the public domain. So if you can complete this novelty search successfully in a thorough manner, there is a scientific process to finish a novelty search. Normally, patent office will be doing this novelty search, like engineers like us from different backgrounds. They will be hiring, and they will ask you to search in a paid database and free database are there. They will search for the novelty search. What does the novelty search mean? Whether your invention, the invention that really want to be protected, that is really novel or not. Novel means new, whether it is a new or not, whether it is existing in a prior art or not. If it is exist, then there is no novel element in that. And so that is one kind of novel research. And another one is patent landscape analysis. It is something like you are visualizing the patent data to identify trends. For example, you really don't know what kind of invention you have to come up with. So you are from a computer science student and you wanted to come up with some invention, because nowadays in your resume they are looking for, did you file any patents, any granted patents are there, or any intellectual property rights you are holding. That also will give a value to your resume. If you have that, immediately you will get a job as soon as you finish your degree. So definitely they will see. So you decided, let us come up with some invention where I can patent this invention. So in that case, what you can do? You can do a patent landscape analysis. For example, you want to come up with the invention in some specific area in a computer science. So that specific area or any mechanical domain or any kind of domain. So you can find out any gaps are there in the technology. And any R&D options, any research and development, any investments are there. If something is not there, if you find out any white spaces means basically like there is a gap in the technology, in the specific technology. That kind of search you can do, and based on that search you can find out the gap. So in this area there is a potential chance of filing a patent if you can come up with some invention or any. After you come up with that patent landscape analysis, you also can come to know that any collaboration opportunities are there, and R&D investment decisions and innovation strategies. So all these things you will be realized if you can do a patent landscape analysis. Basically, if you want to come up with the invention, you need to find out where exactly the gaps are there in the technology, or for that matter in anywhere. So if you can come to know by using this patent landscape analysis, you take some specific technology and identify what are the gaps. Gaps means any area which is not available in the public domain. So any problem is there, you try to solve whether I can solve it or not. That kind of analysis you can get it through patent landscape analysis. So in that way you can find out the gaps in that area, you can work. If you want to file an invention, definitely you need to know where exactly the gaps are there. In this area, I can come up with some developments. That area, if you can find it out by using patent landscape analysis. And patentability search, if you have come up with the invention, so in the novelty search, you are searching for the novelty, and patentability search, Apart from the novelty, you are checking about inventive step and industrial application. These three, whether my invention is patentable or not. So that you can get it done through patentability search. And freedom to operate search or analysis. This is basically to avoid the, for example, one company has come up with some invention and they filed a patent and their patent is granted. Now they wanted to launch their product in the market, for example, in Indian market. So before they are launching, they wanted to make sure that their patent is infringing anybody's patent. I mean, their product is infringing anybody's patent. They wanted to make sure, because after you launch and if it is in the hands of customers and if you produce a lot of manufacturing products and if somebody come to know that you are infringing somebody's patent, then that is very costly to negotiate with that patentee whom you are infringing, and as well as if you want to close the company, it is a huge loss for you. So to avoid all these things, especially to avoid the patent litigation risk, you are conducting a freedom to operate search. Normally in the law firms, they are doing these 4 kinds of searches. So this is one of the prospectus for a computer science student, or for that matter for any engineer. So if you are good in searches, you can prefer this. You no need to come up with some invention and file a patent. You can assess the patentability of somebody's invention, or you can assess if anybody want to launch their patented product in the market. They wanted to check whether they are infringing somebody's patent or not. So that is called freedom to operate search, or novelty search, patentable search, patent landscape analysis. If somebody want to come up with some invention, so they can find out the gaps in their technology. For example, any kind of technology, the computer science or medical or civil or anything, any stream, if any gaps are there, you need to understand the landscape of that technology. Then you can find out what are the gaps, what are the problems, whether I can invest time on this and come up with a solution or not. So as I said, these benefits are informed decision making. After they search whether the client, I mean any company or not, they will get informed decision. Before you enter into the market, you will come to know. Even before you file into the patent, whether it is really patentable or not. Uh, uh, why to pay the extra fee for filing, and tomorrow if that is a useless patent, you are unnecessarily spending the money on that. And anyway, if the patent is on your name, people will easily come to know that like the patent you filed is not having much potential. So before that only, before you file the patent, it's better that you do the novelty search or patentability search and make sure that is patentable and then file it. And risk reduction, as I said earlier, strategic planning and competitive advantage. In that case, you will get a advantage over a existing competitor if you search properly. For example, patent landscape analysis and freedom to operate. And next major activity which related to patents are patent prosecution. Patent prosecution is whatever it happens in the patent office. So there are 4 patent offices in India: Mumbai, Chennai, Delhi, and Kolkata. So for our region, that means Andhra Pradesh and Tamil Nadu and other southern parts of our patent office is Chennai. It is in Chennai. So all the patent prosecution nowadays, everything is online. So all the patent prosecution that happens in the patent office is called patent prosecution. So objective is patent prosecution involves the process of preparing, filing, and prosecuting a patent application with patent office to obtain a granted patent. Our office, it is a center for intellectual property rights. Here, we file a patent. That means we give it to the third party. If anybody has in the university, if anybody has come up with the invention, they can directly come to our office and they can file. We will facilitate how to file and all. We will take care of all the procedure, but we will forward it to the concerned law firm if that is having the patentability potential, if your invention is having. So the filing and prosecuting a patent application with the patent office. So I said, right, patent office there in the 4. we facilitate it. This center is we facilitate because you guys all are part of Andhra University. So we provide an invention disclosure form where you guys can enter the what is the invention and what is the potential of that invention. So you can do the basic Google search and say that it is a novel also, and all that information you can enter in the invention disclosure form, and we will take up the process of filing with the patent office. We give it to third party, some law firm, where they will take care of filing your patent application in a patent office. So that kind of facility actually we are providing. I'm just giving the information. So whatever that happens in the patent office, that is called patent prosecution. So before you come up with some invention, you will search for the prior art. Prior art means already existing knowledge in this world. Whatever the existing knowledge is there, that is called prior art. It's already available. That's the reason it's a prior art. So you need to search in the prior art whatever the invention you are proposing, whether that existed already or not. If it is not there, then only you can go ahead with the invention. So prior art search and drafting patent application. Drafting patent application is nothing but you find some invention, right? So that invention you need to write in terms of you need to write description and everything. But you need to protect in legal terms. Okay, that we call it as claims. Okay, that IP attorney will be take care of that. I am IP attorney. So those claims part, we will take care of that. But you need to understand what are the claims. So writing the claims and submitting it to patent office, everything comes under patent prosecution. If you want to do a patent prosecution, you need to be an IP attorney. You need to write a patent agent exam, or you can be, that is the only way, patent prosecution. So patent analytics, you no need to write anything. As an engineer, if you finish your engineering, you can directly apply for patent analytics as well. So patent prosecution, it is completely whoever clears the patent agent exam, for those people only can do this one. If you are applicant, you are also eligible to do that for your invention only. If you are applicant to that, that means you are the invention. You don't want to rely with the IP attorney, then you also can be allowed. But it is always advised to get it done, your claims, your invention claims through IP attorney. It is always best to get it done through IP attorney. So whatever it happens in the patent office, drafting the patent application, patent office interaction. After you file a patent, you write a description about your patent. What is the exact process to come up with that invention, whatever the potential invention you are describing. And also you need to write a claims also. Claim means a legal language. That is basically in a legal language you are writing that this is the exact invention that I wanted to protect from competitors or from anybody else in the world. So that there is a language, that language is called the claims. Okay, that is called drafting patent application. And patent office interactions means once you file a patent, after publication, you need to request for the examination of your invention. In the examination, in the patent office, somebody will check, examiner will check that. Again, you will check that, novelty, inventive step, and industrial application. And other criteria, I will, non-patentable subject matter. Your invention should not fall in the non-patentable subject matter. Also, ma'am just discussed in the last class. So all these things will be examined in the patent office, and if it is not in compliant with that novelty or inventive step or inventive step or industrial application or non-patentable subject matter, so patent office will give a objections. Okay, so this is called patent office interaction. Then you need to give reply back. Normally IP attorney will take care of that. So grant and maintenance, successfully obtaining and maintaining granted patent. After a patent is granted, there are some process like you need to pay the renewals and all those things, and benefits, securing exclusive rights, protecting inventions, and enabling commercialization. Because you followed all this prosecution and your patent is granted, then you can go with the commercialization. and patent related activities. So patent litigation, whatever it happens after the grant of the patent. So especially infringement or if somebody invalidate your patent, okay, after grant of the patent, since from the grant of the patent, since 12 months from the grant of the patent, somebody can invalidate your patent as well. Somebody can invalidate, somebody can challenge that, this is not having novelty or inventive step in industrial application. Remember that if patent office granted your patent doesn't mean that it cannot be challenged. So you got the patent. Uh, so anybody else can challenge your patent that something is not followed, though your patent is granted. So post grant, I said, right, 12 months since from the date of grant, somebody can challenge in the patent office, or somebody can challenge even after that in the court. And also, if somebody is infringing your rights, that means without your consent, somebody is using your invention, you can you can drag them into the court, because they are infringing your invention. They are not asking you without your permission. They are using that invention. So so patent litigation is nothing but after the grant of the patent, whatever that happens, that comes under patent litigation. So if we in the infringement suit, if you are successful, you will get the damages, and or you will get the settlement also before out of the court through negotiations or ADR, alternative dispute resolution. And even enforcement part, especially enforcement means that will happen in the court. For example, your right, somebody is violated. So to protect your right, so you need to approach the courts. That is called the enforcement. So the enforcement also, that all comes under patent litigation. And the final one is, I discussed, right, patent related act is actually four. One is patent analytics and patent litigation, patent prosecution, patent litigation, and this is the license or acquisitions. Normally, once your patent is granted, your patent can be commercialized. Commercialized in the sense like commercially, you wanted to, because you are a patent holder, you can give it a license to somebody so that they will pay a royalty for you, or you can have an agreement with some company that you can use my patent so that you can pay the royalty of this much, and all these activities will come under a licensor or acquisition. Acquisitions is nothing but mergers and acquisitions. For example, two companies are merging, or two companies are some Google is acquiring some small company. So you need to assess what are the existing intellectual property is there in that. So all those activities comes under license and acquisition. So this also, this is for lawyers. So patent analytics is for any graduate engineer, which is suitable for any science graduate, and patent prosecution is for patent attorneys or patent agents. Uh, uh, you can write, any science graduate can, that means computer science students also can give the patent agent exam, and they can grab the job opportunities in the field of patent prosecution. And the third one is patent litigation, that is exclusively for the lawyers. I'm a lawyer, I'm an engineer, I'm a lawyer, I'm a patent agent as well. So I can cover all this, even license and acquisition also I can cover. So I'm just giving the prospectus so that you can choose the path in these areas as well. I'm just giving the information. So now let us come to patentability criteria. So ma'am just discussed that what is novelty, what is in step, and what is industrial application. So I just gonna recall it. And subject matter does not fall under section 3 or 4. Non-patentable subject matter also ma'am discussed. And I want to insist on written description requirement at best mode, and filing or priority test. I said what is filing or what is priority test. Now I am going to discuss the further slide. So here data filing or data priority test. priority dates. So date of priority is nothing but, for example, if when you file a provisional patent application, what is meant by provisional? Here the provisional means, for example, you have come up with invention and almost 70-80% you have come up with the invention, but you are not sure exactly remaining 20%. In that case, rather than waiting for your invention to be completed fully, you better go and file a patent, because we India follow first to file process. Whoever files the application first, those people will be given the priority. So first to file we follow. When you file a provisional patent application, that means you still have 12 months to file your full-fledged invention that you need to file before 12 months. That is called complete specification. So when you file a provisional patent application and then later file a complete specification application within 12 months of provisional filing. So the priority date for invention is here indeed the date of the provisional specification file. For example, if you file a patent application, provisional patent application, you are not sure about your invention exactly. You have come up with the invention 50-60%, still you can file a patent. That is called a provisional patent application. But make sure you have to come up with a full-fledged invention and the corresponding specification. Specification means writing about your invention completely. Within 12 months, you have to do that. So that is called the complete specification. So here in this case, what is the priority date? Whenever you file a provisional patent application, that is called the priority date. And the date of priority refers to the date on which an earlier patent application was filed in a country what is a member of the Paris Convention. So the first point, whatever I discussed, that is related to India. So in India, if you have come up with some invention, first you go for the, and if you are not sure fully, you can go for the patent provisional application. And within 12 months, you have to file. Otherwise, your application will be amended. So that you have to remember. In this case, priority date is date of filing of the provisional patent. And there is another way of, there is another scenario of understanding date of priority. For example, if it is not India, for example, if you want to protect your invention some other country as well. For example, in India, you filed a provisional complete specific because you are not sure that you have not come up with the invention fully. So within 12 months, you have to file complete specification, and also within 12 months from the provisional specification, you have to file in other countries where there is a potential for your invention. For example, you think UK also the invention whatever you have come up with that is having some potential. So in the UK market also my product or process or product by process is having some potential. I wanted to protect in that country also, because if you don't file in that country, it cannot be protected in that country, because you are filing in this country, and if you don't file in that country in a specific time period, which is 12 months from the date of provisional application in India, then your patent is not protected in UK or USA or any other country where you want to file. So in this case, date of priority is the first filing of your provisional application in India. For example, rather than filing a provisional patent application, you can also directly file a complete application as well, or complete specification application as well. If you are sure that you are 100% sure that you can this invention works and this invention is perfect, directly you can file a complete specification. So without filing a provisional patent application. In that case, date of priority and date of filing both are same. And if you want to protect in other country, so because you directly launched a complete specification application in India, so within 12 months of complete specification, you need to file in other country. So in that case, date of priority is date of complete specification in India. So when an inventor or applicant files a patent application in one member country, see, Paris Convention is or a member of the World Trade Organization. So Paris Convention is something like, whoever is contracted this treaty, that means whatever the countries, almost all the countries in the world contracted this Paris Convention. So if you want to protect your invention in other country, as soon as you file in India, within 12 months, you try to protect in other country. Otherwise, you cannot protect your invention. So data, so I'm just taking the example to make you understand better, because this is very important one. I'm insisting. You need to understand what is this priority date and what is this filing date, and what is provisional patent application, what is the complete patent application, complete specification or provisional specification. So, for example, you filed on January 1st, 2023. So this initial filing established your priority date, which is January 1st, 2023. So recognizing the need to provide more comprehensive details and claims, you work on preparing complete patent application over the course of the next 12 months, because you are not sure that your invention is you have not come up with the complete invention. So in that case, you have a 12 months of time in which you can come up with the complete invention. So within 12 months of data priority, you need to file a complete specification. So for example, on December 31st, 2023, within 12 months window allowed for priority claims, you submit the complete application. This becomes your filing date for the complete specification. For example, you file in January 1st, 2023. So 12 months is January 1st, 2024. So within that time, you need to launch your complete specification in India. And also, if you want to protect your invention in other countries, there also you need to launch within that time. So in this case, what is the priority date? Here your priority date is January 1st, 2023. So in the case of Paris Convention, I told earlier, if you want to protect in other countries, something like US or UK. So since from the date of filing of your application in India, or for that matter, anywhere else in the world, within 12 months, you need to launch your application in another country. So apart from, hope you understand what is filing date and what is priority date. So filing date, your patent term will be always from the date of filing. So 20 years of term, you may get the bit or MCQ that what is the when the term of 20 years will be started. So that is from date of filing. And also you need to understand about specification. For example, you have come up with some invention. So that invention, you need to file a patent. So to protect your invention. So while filing your patent application, you need to write a specification. Specification means written description and corresponding enablement. What is written description? You have to write in such a way that you have to fully and particularly describe your invention, because patent is a quid pro quo. Something like, I give something and government will give it back. What you will give the complete disclosure of the invention. That means fully and particularly describe the invention and the method by which it is to be performed, how it has to be performed. That also you need to clearly mention that. So that requirement is called written description of enablement. So when you file a patent, whether it is a provisional or complete, you need to write a complete. By the time you file a complete specification, in the complete specification, you need to write very clearly about your invention. How to, what are the steps that are needed to produce this invention, whether if it is a process, if it is a product, how to make that product. And also enablement requirement is the person who is ordinary skill in the art. For example, ordinary skill in the art means, that is, I am saying POSITA. The first letters I have taken. Person, ordinary, skilled in the art. POSITA, POSITA. So POSITA means the person who is in the field of computer science. For example, you file a patent in a computer science field. So patent office will check it, will identify a person who is a person ordinary skill in the art, for example, computer science field, he will be able to understand your written description and he will be able to reproduce your invention without undue experimentation. So to reproduce, because you write something in such a way that if nobody understands, so this is then you won't be given any patent, because one of the requirement that you need to get the patent is your specification, that is written description enablement fee should be proper. Apart from novelty, inventive step, industrial application, and your patent should not fall in non-patentable subject matter, and also your specification should be proper. That means written description and enablement requirement also you need to satisfy. Then only you will be given with the patent protection. So I just wanted to insist you. So these are the criteria if you want to get a patent. What are the criteria? Novelty, inventive step, and industrial application. You need to satisfy these three things, and also your invention should not fall into non-patentable subject matters. That is under section 3, under section 4 of the Patent Act 1970. Whatever the non-patentable subject matter ma'am just mentioned in the previous class, all those, your invention should not fall into that kind of subject matter. So apart from these 4 criteria, 5th criteria is specification. You have to write, if you satisfy these 4 criteria, you have to write a specification in such a way that it should be understandable and able to reproduce it without any undue experimentation. So that is the enable requirement. And written description is it has to fully and particularly describe the invention, how you need to reproduce the invention. For example, if you file a patent and it is published after 18 months. So I'm a person who is a computer science student. I can read your written description. I should be able to come up with your invention. I should be able to reproduce it. In such a way, you need to write your specification. That part also will be checked in the patent office by examiner. He will check novelty, inventive step, and industrial application, and also he checks non-patentable subject matter, and also he will check specification whether you have written properly or not. Enablement requirement is there, or written description requirement is did you disclose sufficiently, sufficiency of disclosure, that is called, is did you disclose properly or not. So all the requirements are satisfied, then only you will be given the patent. If it is not satisfied, examiner will give a objection, will issue a office action. That means first examination report, that is called. He will issue a first office action to you saying that these requirements are not satisfied, please comply with this. Okay, so those things I will be discussing in further. And also best mode requirement. Best mode is nothing but the best mode of performing the invention which is known to the applicant and for which he is entitled to claim protection. What does it mean? That means while filing the patent application, you are filing a complete specification, first provisional and complete specification. So whenever you file a complete specification, by that time, what is the best method you know to reproduce that invention or perform the invention, that information you need to provide. That is the best method. See, for example, if you want to come up with some invention, there might be some 3 or 4 ways. In that, what is the best method you need to mention in your specification. That means the specification will be in the complete specification application. So I am insisting that if you have come up with the invention, you need to satisfy novelty, inventive step, and industrial application, and it should not fall on non-patentable subject matter. Apart from that, description, specification you have to write in a proper way, which you should satisfy best mode and as well as written description and enablement requirement. Okay. So now you can see what exactly I am talking about. Okay. So after you file the patent application, uh, provisional, and after that, within 12 months, you need to file a complete specification. So the moment you file a provisional or directly complete application also, you can file. So the moment you file a patent application, for example, if you are Indian resident, and imagine your patent falls in a non-patentable subject matter, imagine. Okay, and you wanted to, you before filing the patent only, you come to know that you cannot file in India. You cannot protect your invention in India because your invention subject matter falls in the non-patentable subject matter. So then what you can do? You can take the permission. You need to, if you are Indian resident, you have to take the permission from the patent office. So you can write a mail. You can take a permission to the patent office, and patent office will give a reply within 21 days that whether you can file in some other country without filing in India because it falls in the non-patent subject matter. Just I am giving one example. So in that case, within 21 days, uh, within 21 days, patent office will give a reply that whether you can file the patent in other country or not. For example, you feel that if you file your patent in US, you think that there is a lot of potential in the US and India anyway. You feel that that it's not much useful and also it falls under non-patentable subject matter. So what you can do is you can take the permission if you are Indian resident, and you can within 21 days patent office will give a reply and you can without launching patent application and filing a patent application in India, you can directly file in US or any other country in the world. Uh, or else there is another option that you can file in India and wait for 6 months, sorry, 6 weeks, and after that you can file in any other country. So these are two options. Basically, why they need some time, why they made it mandatory, because if your invention which is related to some atomic energy application or something like that, so they wanted to check it because that information, that secret, that information or those kind of patents, patent office or government of India won't allow to file in some other country. So to check this information, actually they are going to they made it mandatory that if you want to file application in overseas without filing in India, take a permission within 21 days. You will get the permission. They will say whether you can proceed or not, or you can file in India, wait for 6 months, and you can go with the abroad. Wait for 6 weeks. So just basically to make sure that it is not a invention which are related to atomic energy. And after you file the provisional application within 12 months, you have to file a complete specification and publication 18 months from the date of priority. Here the priority is provisional application because first you file a provisional and then complete specification. So within 18 months from the date of priority, so automatically your application will be published. That means whatever the information you provided in your application while filing a complete specification or provisional specification, that information will be published uh, after 18 months automatically. That is called publication of the patent application. So, and also after that you need to request for the examination, that because your invention is published well and good, and now you need to get it examined with the patent office to check the novelty, inventive step, and industrial application, and also non-patentable subject matter, and also specification requirements, written description or enablement, and best mode. So all these requirements, whether you satisfied or not, some person from patent office, he is called the examiner, patent examiner, he will verify it. If he satisfied, then only he will give the patent. For that, you need to request the patent office by paying the fee through Form 18 or Form 18A. By paying the fee, then only they will consider your request. It cannot be done automatically like a publication. Here the publication automatically after 18 months it will be published. For request for examination, you have to pay the money and you have to request them. Whom you have to request? Patent examiner in the patent office. So that you need to do within 48 months from the priority date of your application. Priority means first filing, whether it is a provisional or complete specification or whatever may be. So first priority, first filing application from that date within 48 months, you need to request for the examination. If you don't request, your application will be abandoned. So after publication, after 18 months, publication will happen, and after that, request for substantive examination. So as I said, you can request for the examination within 48 months from the date of priority. So and issue a first examination report. Once you request for the examination, they check for the novelty, inventive step, and industrial application, and specification and non-patentable subject matter. And if you are not comply with that, they will issue a office action. That is called first examination report. They will reply, they will send a mail or reply to you saying that you need to comply with so and so. You are not complied with that, or they will examine that examination report. They will send, that is called first examination report, and you need to respond to back. Everything IP attorney will take care. You don't need to worry. So response, you should submit response within 6 months, or it can be extendable 3 more months, maximum 9 months. So within that, you need to completely give the reply and make examiner satisfy that you satisfy novelty, inventive step, whatever the comments he has given, wherever the objections he has told, everything you need to tell them. You need to reply in a proper way, and you have to make him convinced. If with your reply, if he is not convinced, you can request for hearing and you can convince him. And if he is okay with that, you will give the grant. For example, after giving first examination report, and if you can justify that it satisfy all these criteria, then also without going for hearing, the patent will be granted. Only thing is, you have to convince examiner that this patent is satisfying novelty, inventive step, and industrial application, and non-patentable subject matter, it won't fall. And also specification also I provided properly, fully describe the invention and best mode and enablement. So in that case, you will get the grant. So I have given in between, before grant of the patent, anybody, doesn't matter, anybody else in the world can oppose your invention, oppose your application, saying that it is not satisfied with the patentability criteria, novelty, industrial application, all that stuff. So before the grant of the patent, starting from the filing of the patent application, so whatever in between anybody can oppose. So that kind of opposition is called pre-grant opposition. So post-grant is nothing but after the grant of the patent, within 12 months from the grant of the patent, if anybody opposes in the patent office, then that is called post-grant. So pre-grant or post-grant or whatever may be, so it should be within the patent office. So filing from the date of starting from the date of filing application and till the grant of the patent. So pre-grant opposition, and after the grant of the patent 12 months, it is a post-grant opposition. So whatever that happens, that is after 12 months of the post-grant, sorry, after the 12 months from the grant. So whatever, if you want to invalidate, if you want to enforce your right, or all those things comes under enforcement, that will be happen in the courts. So far we discussed about process of obtaining a patent in India, provisional and complete specification I discussed, and convention application. PCT also, patent cooperation treaty, I discussed. I wanted to discuss PCT as well. PCT is nothing but there are some drawbacks in Paris Convention, because within 12 months from the date of filing, you need to file. If you want to protect your invention in different country, you need to file in other countries also within 12 months. For example, if you think your patent, your invention is having potential to be protected in some 12 countries, within 12 months filing in 12 countries is very difficult. So to avoid that, you can go for the PCT application. PCT means Paris Convention. So Paris Convention Treaty, sorry, PCT is nothing but Patent Cooperation Treaty. So Patent Cooperation Treaty will protect your priority date in all the countries, all the member countries of the Patent Cooperation Treaty. So Patent Cooperation Treaty, almost 158 members, 153 so far member countries are there. So if you want to file patent within 12 months to protect in different countries, so and if it is more than 4 or 5 countries, it is very difficult to file more than 4 or 5 countries within 12 months. So to avoid that, there is another system through which you can protect your priority date in 153 countries, because Patent Cooperation Treaty members are 153 member countries signed Patent Cooperation Treaty. So if you have any doubts with respect to whatever I have discussed, you can ask the questions. Participants, I just opened this. Maybe she can say. 153. 153. 153. If you have any questions, you can ask. So if there are no doubts, we can wind up. Yeah. Okay. So can both trade secret and patent can be granted for a product? Actually, trade secret is nothing but if you want to keep something secret, that is called trade secret. Patent is completely opposite. Something like, you need to disclose your patent invention to the government, so that government will give a monopoly, some exclusive right. So both are contradictory. Hope this clarifies. Korada Chaitanya. Anyone is having any question?